So tonight we have breaking news in Donna Adelson's case, which is why I'm going live a little early because I could not wait to talk to you about this. Judge Everett has denied Donna Adelson's motion for a new trial. We are going to talk about what that means, and we are going to talk about what's next for Donna Adelson because it's not all over, but boy, this is a really big, important factor. What's just happened is a big deal. So we're going to walk through the order. I'm going to show it to you exactly. You can see what the judge wrote, what the judge said, why he said it, what his reasoning was. And we're also going to talk about what Donna's arguments are, because Donna's arguments are what's going to be made most likely on appeal. It's not that there's complete overlap, but it does give us a window into what she thought was the most important. So normally, like I said, we go live at 7 p.m., but I just wanted to get this to you so quickly, and I didn't want to wait. So here we are. All right, so we are going to break all this down in clear English. It's not going to be hard. And so we're going to talk about, first of all, I want to just go over what is a motion for a new trial? Why do defendants file those? So a motion for a new trial is sort of an intermediate step. Right after a trial, if a defendant has been convicted, then the defendant knows that there's an appeal ahead. But a motion for a new trial would be even faster. That's where the defendant tells the court, look, this is such a fundamentally flawed trial. We should just start over right away. We don't even need to go to the appellate court. We should just start right now. And if we start right now, then that is going to show us exactly why this trial is wrong. We're going to start all over. And this would cut off the appeal. The trial would happen again. And then when the trial happened again, then after that, there could be an appeal. But the trial would happen first, the new trial. So defendants filed these for obvious reasons. It's kind of a second bite at the apple, right? That there's another chance that they could get rid of this and that they could win in a new trial without having to go through the appeals process. And are they ever granted? Of course they are sometimes granted, but I will say it is really rare. It is very unlikely that a court will grant it. And you just kind of think of where the court is in this process. The court has just sat through an entire trial. A jury has been brought in. They've heard all of the evidence. Everybody has put this in front of the jury for days, weeks in the Donna Adelson case. There have been witnesses, there's been testimony, there's been evidence, there have been rulings from the court, and 12 or more with alternate citizens had to sit there and listen to all of this. So unless there's a really, really important problem, it's really unlikely that the court is going to say, okay, let's do a brand new trial. It's just not very likely to happen. And so normally these are not super successful. But the fact that it's denied doesn't mean it's 100% over for Donna Adelson. It means she'll stay in prison. It means that nothing will happen until after the appeal, which could be a year or two. So it means things stay the way they are. She wanted a new trial, a start over right now, a do-over immediately, and that's not going to happen. So we're about to dive into the order, and you'll actually see what the judge said about it. I want to give a special shout out to Cutley, Tart with a Heart, Meme, Catherine Fraser, and Debbie Sue, all of whom were our first 5 in the chat. Thank you very much. So let's go ahead and pull up the motion, and actually order is what I should call it. This is the court's order denying Donna Adelson's post-trial motion. So she asked, if you will remember, we covered this one in pretty good detail, to interview 2 of the jurors. These were jurors who had made interview statements. One of them had posted TikTok posts on her own TikTok channel. I guess you call it a channel for TikTok. Sorry, I don't know. So here's what the court said. The court said, well, first of all, what's my standard for deciding whether you get to do what you want to do? Which Donna wanted to interview these 2 jurors. You can see why a court would not want that to happen. That would be really unusual. What would it do? It would, first of all, make people less likely to want to be jurors. If after the trial you have to be interviewed by the side you voted against, Really awkward, right? And so that you don't want that, if possible, in the court system. So in this case, the judge said, okay, here's the standard I'm going to use. Juror interviews are not permissible unless the moving party has made sworn allegations that, if true, would require the court to order a new trial because the alleged error was so fundamental and prejudicial as to vitiate the entire proceedings. And the judge said that's not the case here. Defendant's allegations do not establish a prima facie case of jury misconduct, but instead encourage the court to engage in a procedure disapproved of by the Florida Supreme Court. So, in plain language, they're saying, in general, we're not going to let anybody interview jurors until it would be the allegations are so strong, so big that the court would have to order a new trial if that really were true. If it's that important, then we're going to let you do that. But otherwise, no. And he's saying, look, this is not the case here. This is what these jurors did and said is not that big a deal. And he starts with juror number 5, who, and this is from Donna's motion, a quote, he revealed he considered how defendant reacted to the evidence and testimony during the trial. So juror number 5 talked about that. But then on the other hand, so what? And then defendant's motion concedes that juror number 5 said he did not consider defendant's reactions when deliberating. And here's what the defendant is arguing. Donna Adelson is arguing. She's saying, look, I didn't testify. And so you can't use the fact that I didn't testify against me, and you can't assume that the way I react or look during the course of the trial means I'm guilty. You can't do that. And therefore, juror number 5 looked at how Donna Adelson reacted, and that's not allowed. There were 2 flaws with that, the court said. Number 1 is juror number 5 said, I didn't count that. When we were thinking about and deciding the actual case and convicting Donna Adelson, I didn't consider that. But then there's a more fundamental issue, which is, frankly, it's impractical to say to the jury, never look at the defendant. Don't pay any attention to what the defendant looks like or to their reactions. And the court said it is not impermissible for jurors to visually observe the defendant over the course of a trial. In fact, it's pretty normal. It's exactly what every juror does. They look over at the defendant and they consider, who are they? Who is this person? And whether or not they testify, they do at least look at the person. It's part of the right of confrontation that the defendant has. So the bigger issue by far was juror number 7. If you remember back when we talked about the request to interview juror number 7, Donna's team had told the court in the brief that there was a secret recording. What am I saying? There was a secret TikTok that had been deleted, and that they believed they had a copy of it and they were going to show it to the court. Wow, what's in this secret TikTok? Well, here's what the court says about what they turned into him and showed him. The argued reason for interviewing juror number 7 is that she posted on TikTok that she was selected as a juror on August 26, 2025. Defendant provided a video recording of this post, and the court was also able to locate the post on the juror's TikTok account, where it remains an active post as of the filing of this order. So that's pretty important already. Because what we're hearing is this statement that there was this secret, now deleted TikTok, not true. It wasn't actually secret. It's out there still in the open. And it displays the following text over video of juror number 7. When I told God I needed a break and he makes it so I am selected to serve on a jury for a 2-week trial, all caps, won't he do it? Smiley. Along with the caption that reads, no work, no kids for most of the day. You know what? Heaven. Yeah. And you may remember we talked about that might be what this was. There's nothing in there that talks about the trial. And that is the touchstone. And juror number 7 said that in interviews. She said, well, I never talked about what was happening in the trial. She talked about that afterwards, but she was entitled to do that. There's nothing wrong with talking about that afterwards. And in this post, she said nothing about the trial at all, just that she was going to serve. And you'll see that's exactly what the court calls out. The court concludes juror number 7's TikTok post does not constitute communication about the case. Rather, it was a comment about her jury service and its length. It does not reveal the parties, the attorneys, the alleged crimes, whether it was a civil or criminal case, or even the location of the trial. So with none of that information, it's really difficult to conclude that this juror did anything improper. And the judge is going to say, look, it's got to be so strong under the law that I would have to give a new trial if these facts were proven. And if you manage to prove that she went on and said, yay, I get a couple of weeks off and someone else is going to have to deal with the kids, that is nowhere remotely in the vicinity of grounds for a new trial. And so here's what the court says. Furthermore, every prospective juror was informed. If you are picked for the jury, you may tell people that you have been selected for the jury and how long the case may take. However, you must not give anyone any information about the case itself or the people that are involved in this case. And even if they manage to prove everything about that TikTok post, nothing in there suggests anything about the case itself, doesn't even name the case, or the people involved in the case. If Donna Adelson has something more, it appears she didn't present that to the court. All she has is this TikTok, which did not have anything related to the case. So that's a pretty significant point. All right, so let's go. Let me go ahead and, oh, fantastic. Kim is a new member. Welcome. We are really glad to have you join us. Thank you so much. By the way, I forgot to say, would you please hit the like button if you're just coming in, or if you've already been here? If you would do that, I would really appreciate that. That helps YouTube know, yep, we're live and we're here, and it wakes YouTube up. Salty Buzzard has been a member for a month. We are so delighted. Thank you so much for being a member, and is concerned about Donna Donuts. Interesting. Was there a period where she ate donuts? I can't remember. I don't remember that, but I like the nickname. All right, Marlon, little off topic, but Jerry wants to show his soccer ball. Okay. So I think Marlon has a new, what do you call those? A new picture for his name. Marlon is one of our two mods here, Marlon and Mama Pinks. I am so appreciative of them. And Jerry, Marlon's dog, we are fairly certain, thanks to you, the most famous dog in the Netherlands. So we all say shout out to Jerry. And thank you, Neuropsych Zena. I appreciate that very much. Well, let's head on into what the court said about, and so we'll just stop with that. That's no interviews of the jurors, and it wasn't even close. It's not even, now that we know what this secret TikTok was, it's really nothing. And so I don't think there's any grounds for a new trial in that. And now we've got the grounds for the motion for a new trial and renewed motion for judgment of acquittal, which, and so the motion for new trial would be, let's do another trial right away. A judgment of acquittal would be, there's not enough evidence here to convict Donna Adelson. There's zero chance she's going to win on either of these. And spoiler alert, now that we have the order, she did not win on either of those. So let's talk about what the arguments were and what the court said, what Donna's argument was. So first of all, she argued, this is outrageous. It's the fact that this jury would convict me is contrary to the law, and it's against the weight of the evidence. In other words, there is just not enough here to legitimately anyone think I was actually guilty. That's her argument. So, and the court, it will not shock you, does not agree with Donna's team. Here's what the court said. The court does not find the jury's verdict is contrary to the law or the weight of the evidence. There is evidence in the record demonstrating overt actions by the defendant in furtherance of the murder for hire scheme. And then the court goes into some of the specifics about what those are. And here's some, and we can probably catalog another 20. The trial evidence demonstrates defendant's objective for the crimes being completed as separate and distinct from her son, the middle woman, and the trigger men. However, their combined acts resulted in the crimes committed and death of the victim. Because the objective of certain co-conspirators here was obtaining money through criminal acts, the death of the victim did not terminate the conspiracy until the co-conspirators received their payments. The trial evidence established defendant's connection to those payments. So what the judge is saying is, look at the fact that I acknowledge that Donna Adelson didn't pull the trigger. I acknowledge that Donna Adelson didn't actually ever talk to or hire the trigger men. But all of these combined acts working together are how Dan Markel ended up being shot and killed in his driveway. That the objective was always money. And it was Donna who made sure of that. And the court is raising a really good point, which is that objective that the trigger men be paid continued as long as they were continuing to be paid. And remember that Donna Adelson wrote numerous checks to the middle woman, as he calls her, Catherine or Katie Medbanwa. Katie Medbanwa, Charlie's girlfriend around the time of the murder, was the ex of one of the trigger men. And the prosecution says, and juries have convicted all of the people on exactly those grounds, that Katie hired the two hitmen and that Charlie paid her using money from that the prosecution said came directly from Donna. But even more than that, Donna kept paying Katie. It wasn't a one-time thing. There were numerous checks, more than 40 checks that she wrote to Katie Medbanwa over the next couple of years. And the court is saying, when you got ongoing payment like that, that is ongoing efforts to pay money for this murder. And therefore, that's Donna's connection to the trigger men. So there was also an important issue that arose during the trial, and we knew a little bit about it because we got little snippets of the argument, but a lot of the argument was behind closed doors. A lot of the art, so to speak, it was in the sidebars that were up in the front, and we didn't really get exactly what it was. So we're finally getting a window into all of that. And one of the things that Donna felt like just absolutely should have been allowed was the entire planner for the year 2014 and also 2023. When Donna was arrested, the law enforcement went and searched the condo where she and her husband Harvey lived. And they found that she had retained and kept planners for entire years, and she kept them all the way back through 2014 or earlier. In 2014, one of the critical things in that particular planner was that she had written down the vehicle that Dan Markel drove and the license plate of it. Well, that was really important because one of the trigger men testified that that was how they were able to follow the vehicle. They knew what to look for. They knew what the vehicle was. They knew what the license plate was. And here, Donna Adelson had that written in her planner. And given that this was her ex-son-in-law, why? Why did she have that written in there? What was even the point of that? And so the prosecution says, well, we know what the point was. She gathered this information to make sure that the hitman knew how to reach him. There were also entries in 2023 around the issue of selling items right before she left for Vietnam. You may remember that Donna Adelson wasn't arrested in her home. She was arrested while trying to board a plane to Vietnam. And it wasn't just that she was going on vacation, although she argued that, because there was specific evidence that Donna Adelson had spoken to her son, Charlie, and there was a recording of it after she thought the phone had hung up. And in that recording, she was talking about the fact that Vietnam was a country that does not have an extradition treaty with the United States, meaning that Vietnam itself doesn't have a treaty that automatically would let it agree to return someone when requested by the United States. That would mean it might be more difficult for the prosecution to pull her back into Florida if she lived in Vietnam. It became a very important fact in the case, and frankly, one that differentiated her case from Charlie's, made it more difficult for her. Charlie didn't have anything like that. Charlie, her Adelson, her son, was also convicted more than a year ago. So during the course of the trial, the prosecution introduced these points from the planner and said, here are some important points, but they only introduced the relevant pages from those planners. What Donna's team was asking was, don't give us just that. We also want all of the information from the entire planner to go before the jury. And they argued that there were, for example, with the 2023 planner, that it showed she'd been looking to sell items all year long. It wasn't as if she did this right before she was about to leave for Vietnam and never any other time. And so they wanted the court to know that. Well, the problem with that was, we'll read about it here, so I won't go into all the detail here. I'll let you hear what the court said the problem with it was. But they ultimately were allowed to use part of that with the jury. They were allowed to put the item into evidence. What they weren't allowed to do was refer directly to other entries in it. So let's go ahead and look at what the court said. So this is related to refusing to admit the entire planner, as opposed to the pages the prosecution used. Defendant asked to introduce the complete calendars during its case in chief. As an initial matter, the request was untimely and names the Florida statute. Although the plain language of the statute requires the adverse party to introduce the other part of the statement at the time that the first party introduces the statement, Florida courts have generally allowed the adverse party to delay introducing the other part of the statement until cross-examination. Defendant's request was too late because it came after cross-examination of the relevant witnesses. So essentially, here's the point, that the party is allowed to wait, and let's say a witness is up on the stand and there's an important piece of evidence and they want to introduce the rest of it. The defense wants to introduce the rest of it. Well, they don't have to do that. They can wait until their cross-examination to do it. In fact, that would be the logical time when they could do it. But they can't wait until the trial is over and the witness is gone and then do it later, because that way there's no one to talk about it, no one to discuss it with. And in this case, the defendant waited too late. There was a witness who put in these pages. The defense never said, hey, we want these other pages in also, while that witness was on the stand. So the judge is saying that's too late. Next, even if the request was timely, and this is really common in legal writing, essentially what the judge is doing is appellate proofing his decision. What he's doing is saying, okay, I'm right here, and I'm right over here, and I'm right here. It's more than one reason. So the court should agree with me. The court should decide that the appellate court should make the decision that I made the right decision, because there are a lot of different reasons for it. And if the appellate court doesn't buy this reason, then the appellate court should buy that reason. If they don't buy the other reason, they should buy this reason. So that's a normal way that legal writing is done. So he's saying, okay, even if the request was timely, it was improper, because the purpose of the rule of completeness is to avoid the potential for creating misleading impressions by taking statements out of context. By its very nature, a calendar day planner is divided into a series of pages corresponding with the days in the year. Thus, the court concludes the entries the state admitted into evidence were not out of context. They were not one part of a whole. They were specific dates in the calendars referencing specific events, and those relevant entries were admitted in their entirety. Interpreting the rule of completeness to allow for every other entry in the calendars would require the contemporaneous admission of any written or recorded statement that might cast light on an admitted statement. So, okay, breaking that down, what he's saying is that even if this had been timely, even if you'd done that right, which you didn't, he said that's already strike one. And for that reason alone, the appellate court should agree that I'm right here. But also that there's something called the rule of completeness, which says that if you have part of a document that gets introduced and so it's not really accurate, it's misleading unless you put the whole thing in, then you have to put the whole thing in. But that's typically done with, say, a contract and someone tries to put in a paragraph from the contract. Well, the rule of completeness would mean the whole contract goes in. He's saying a calendar isn't really like that. It isn't like May is inaccurate unless you can see April 2. That it's different. The way a calendar is set up, you can pull out one page, one entry. You can do that. So it doesn't really apply. The whole rule doesn't even apply to calendars. That's what the court is saying. And the court also says that even if you put all that aside, remember, appellate court, remember, defense, that I allowed you to use the entire set of calendar entries as a demonstrative exhibit during your closing argument. And then the defendant argued that the state did not want the jury to see them. So the defendant actually said, here's a calendar and the state doesn't want you to see all of the entries. The jury probably did not take the defense up on that and go look for anything, but the court allowed the defendant to make that statement during closing argument and allowed the defendant to use that as a demonstrative exhibit, meaning show it to the jury without it going out with the jury. In addition, the 2023 calendar entries defendant sought to admit would not rebut arguments that she was fleeing to avoid prosecution when compared to the vast amount of contrary evidence that existed beyond the planner. So he's saying, look, it's not like the only way we knew you were trying to go to Vietnam for a long time was because you wrote in the planner that you were selling items. That is not the only reason. Instead, and there were some other things in there too related, but those aren't the only reason. Look at the fact that it was a visa that you had gotten for 90 days. Look at the fact that you didn't have a return ticket to come back to the United States. Look at the fact that you said and researched that it was a non-extradition country. We could all see what you were doing, which was you were trying to leave. You were trying to go to another country so that you could evade prosecution. So the court is saying, for all these reasons, this is not a big deal on appeal. Now, for other cause, and these are just, he's going to group together some miscellaneous arguments that have been made by the defense. After defendant had closed her case, but prior to the commencement of closing arguments, the parties were asked to approach at sidebar. The court explained it had performed additional research and wanted to confirm that defendant did not want to testify. Now, to give you a little background, what happened was the court was actually, it was time for Donna to make the decision. Is she going to testify or not? And she just couldn't make the decision. She was very indecisive about this. So she sat there and she's like, I don't know. And they talked and the judge said like 5 more minutes and said, no, I really mean 5 more minutes. 5 more minutes for real this time. You have to decide. And it just went on and on and on. And the judge is finally like, and I believe the defense lawyer said something about, well, what if she can't decide? And the judge is like, well, I guess I hold you in contempt. I mean, what? And they're going to argue over what exactly was said. But here is what the judge says he said and what he meant. After defense, so he's saying that the court, and this is so important because we didn't know this, but the court said the next day, when they went for closing arguments, the court said, look, I've researched it some more, and I think I need to give you another chance to testify if you want to. I need to ask you again before closing arguments, do you want to testify? Yeah, yesterday you said no, and so we closed out the case, but I'm going to ask you again. So, and the court explained about this additional resource. The court added, the reason why I'm bringing this issue to the party's attention is only because I believe the appellate cases of this state make clear prior to instructions in closing, the exercise of the fundamental right leans toward allowing the defendant to reopen her case if she wanted to testify. So, something completely not mentioned in Donna's brief is that she got a second bite at the apple. She got another chance to change her mind. And here's what she said. Upon the court's inquiry, counsel responded, we talked to her for a somewhat lengthy period of time last night over the phone while we were preparing. She informed Ms. Fulford and my paralegal that she felt secure in her decision. Defendant was then placed under oath and asked if she was absolutely firm about this decision not to testify. Defendant twice responded, yes, I am, but asked for a few minutes to talk to counsel. The court then granted an additional 30 minutes to further discuss her decision. After that time had elapsed, defendant once again stated, I have made a decision. I am not going to testify. When asked if she was firm on this decision, defendant answered, I am. The court concluded, I will make no further inquiry unless the state or the defense seeks for the court to do so at this point. Now, I want to show you what Donna said in her motion for new trial. Let me get to that exact spot, which I think is a little bit further on in here. Hopefully I highlighted that. Otherwise, oh, there we go. Okay. So this is their explanation of what happened. We're going to contrast that with what the court says happened, okay? The state presented evidence and testimony over a period of 6 days. The defense had requested 4 to 5 days for its case. On the second day of the defense's case, the court demanded that Mrs. Adelson decide whether she would testify. Both counsel for Mrs. Adelson, as well as Mrs. Adelson herself, repeatedly advised the court that more time was needed to discuss the evidence admitted and the pros and cons of testifying based on the volume and substance of the evidence admitted during trial, in order to make a knowing and intelligent decision in what was probably the most important decision in her life. This was especially significant in that the state made numerous changes to evidence during the trial. When the court recessed early on September 2nd, 2025, to allow counsel to meet with Mrs. Adelson, we first spent a great deal of time reviewing the exhibits actually admitted so that we could discuss them with Mrs. Adelson. Counsel then drove to the detention center to meet with Mrs. Adelson for the 2 hours authorized, arriving at approximately 5 p.m. Counsel did not have enough time to go through every exhibit with Mrs. Adelson during this meeting. Counsel advised the court of this fact the following day when the court inquired about Mrs. Adelson's decision. Essentially, what they're saying is, we would love to prepare her with all of the evidence. And if the case had taken longer, both for prosecution and defense, we'd have had a bit more time. But we kind of ran out of time because of how fast things went. So there were pieces of evidence the state used that we haven't had a chance to talk to her about. And therefore, we don't know what she would say. And we don't know how bad that would be for her. And if it's going to be bad, we would tell her don't testify. But if it's a pretty good answer, maybe we would tell her testify. So that's basically what they're arguing here. Not only did the court force the defendant to make an uninformed decision, he threatened to hold counsel for the defendant in contempt of court because they were continuing to speak to their client about this important decision that she had to make, which again brought an audible derogatory response from the gallery. Oddly enough, whenever the state needed additional time to set up electronics for opening statement, for witness testimony, for closing arguments, and even additional time to make their closing argument, the court not only gave them the additional time, he joked with the prosecutors about it, thus leaving the clear impression that he favored the state in this case. So essentially, Donna's team has argued here that she did not have enough time because the case moved really quickly and that it was unfair of the judge not to give them more time. After all, he gave the state more time for this and that. Why couldn't he give more time to the defense? But given what the judge said, That argument makes no sense. The judge says he gave her overnight to rethink about it, and then 30 minutes the next morning. That's past even the multiple 5-minute additional extensions that he gave. And you have to remember that there is nothing unique about Donna Adelson's decision to testify or not to testify. It's the same decision that every defendant makes over and over again in case after case. The fact that it's a hard decision is true for every defendant. But when the case reaches its end, every defendant has to make that choice, one way or the other. Is it easy? Absolutely not. But nonetheless, it is a decision that has to be made. And so in this particular case, I think the Adelson team was pretty far off on it, because if in fact what they said, I assume all of this is correct. This is straight from the court. And if all of this additional time is given to Donna, that really should probably have been mentioned in their brief. And it certainly undermines their argument that it was a rushed, pressured decision that they lacked the real time to make. So that concludes the motion. Now let's talk a little bit more. There are a few questions I want to answer to. Let me remove that and make this a little bit bigger. So all of this now, it's with this brand new order that was issued, we now know Donna Adelson is not going to get the free new trial she would have wanted. She would have liked to go straight back into trial as quickly as it could come up again, as quickly as the court could get it set again, without having to go to an appeal, because her chances on appeal are not particularly great. She would rather have a new trial, another bite at a jury, and if she can convince them, then she won't have to do the appeal. In this case, though, we see the judge has knocked it down, and it seems exceptionally strong. If these are Donna Adelson's very finest arguments, then the appeal will be difficult. I don't think these are her only arguments. She didn't have to make every argument right here. So what happens next is Donna gets ready for her appeal, and an appellate court obviously can see this differently from the trial court. An appellate court can conclude all kinds of things are problematic, shouldn't have been admitted. Most of the appellate issues will probably relate to evidence that the trial court admitted, everything from the bump to everything. She will probably argue the financial information was unfairly used against her, things like that. So the Vietnam shouldn't have been used against her because of the fact she had requested permission and been told that there was nothing holding her in the United States. Those are the sorts of arguments that I expect to have on appeal. But what we see right here, not very strong. The judge easily knocked it down. So now, how long would Donna be in prison during this appeals process? Because she's obviously not getting out on appeal. And it often takes a couple of years. I would not be shocked or surprised for it to be 2 years before we get an order from the appellate court. Her chances are low. It's very unlikely that she would even get a new trial on even one issue or one count of one charge against her. I don't think even that much. And it's even less likely that she would get something like an acquittal, a reversal that says, yes, you couldn't possibly have brought this case. We're setting her free. It just doesn't happen. I would be stunned if that happened in this case. And it will be a very long period of time before we even have that answer. So this is huge news in this particular case, in the Donna Adelson case. I wanted to get it to you quickly. Let's go ahead and do some questions. If you have some questions, if you would put those in the chat with question marks at the beginning, it'll help me spot you in the chat. Oh, thank you, Annie K. I appreciate that very much. Annie K has been a member for 19 months. That is awesome, along with Marlon. Y'all are our vanguard. Y'all are the first people out there. I really am appreciating that. Thank you very much. All right, so let me look over and see if people are putting in question marks, preferably at the beginning. Okay. Oh, no, Marlon just telling people to put in question marks. So let's talk a little bit about what the motion for a new trial is for people who are just coming in late. I want to go ahead and start with that while people are warming up to their questions. And this motion for a new trial is sort of an intermediate step. It's something that would happen right away, pretty quickly, as soon as the court could get it scheduled. Could be a matter of a month, or could be probably longer than that, probably a number of months. And it would completely restart the whole trial. That would all happen completely over again. And there might be different rulings, or there might be the same rulings. And only after that, if Donna lost again, would she then have to appeal. But the court is saying, no, I'm not going to give you this free second bite at the apple. I'm not going to give you a free shot at a new trial. Annie K asking about whether or not Donna has strong appeals. The only appeals I think that are decent and decently strong, I mean, relate to the evidence that was admitted. And I particularly thought some of the information around the bump was potentially problematic, but I don't think that any of those are going to move the needle with the appellate court. There was a lot of evidence. There were a lot of different pieces of evidence. I think it's very unlikely. You know who else agrees with me? Is Charlie Adelson. And the reason I say that is because in those early phone calls with his mother that we have from prison shortly after his conviction, one of the things that Charlie says is, there's not much chance on appeal. His attorney, Daniel Roshbaum, has just visited him in prison. And Charlie says, yeah, there's really not a lot of chance on appeal. And he is acknowledging that. And so I think the same would be true for Donna Adelson. I don't think that there would be a huge chance that this particular case would be overturned. All right. Jolie is asking me, can Wendy speak to Donna if she chooses to now that the trial is over? She can, and she could have spoken to her beforehand, I think. I don't know that there was any order preventing that. In fact, I think the prosecution would have loved that. I think it was Wendy choosing not to do that for obvious reasons. I think she feels like it's impossible to get her mother to stop talking about issues related to the case. And she doesn't want to talk about that. She thinks everything that's said could harm her. Why would she talk about that? And in fact, what we see is, for example, when Donna was talking to people in the room, it was recorded by the jail call, even though she thought the jail call had hung up. She's saying, I'm trying to talk to Wendy about this and that, but it's not about the case. But a lot of it was about the case. And so I think Wendy has good reason to be a little concerned about that. As far as her ability to talk to her, though, I think she could if she wanted to. I don't see any reason for that. Julia H is asking me, can Donna and Charlie ever speak to each other again? Such a sad situation. And I do agree with you. It's a sad situation on just about every possible level. And think particularly about the children and how many people they have lost in their lives, even though Wendy still hasn't been charged. As far as whether Donna and Charlie could speak to each other again, I think it would not be easy because they are both incarcerated. They could probably do so through Harvey, assuming Harvey is never charged. But other than that, it could be very difficult. They're in two different prison systems. So as far as speaking on the phone, I don't know what procedures they might have set up to allow that. I think it'd be more likely it would be through letter writing or something like that. Nim wants to know, are there any consequences for the lawyers lying about the cancel TikTok video? So here's how I see it, Nim. I don't think that it was a lie. I think they interpreted it far more broadly than the court or than I do, which is they saw this as her talking about the case. I don't think that's technically a lie. I sure don't see it. If that's all they had, I was expecting a lot more than that. With this secret TikTok now deleted, I thought they were going to have a lot more than that. It's really not an impressive amount. All right. Negative Mass wants to know, so Donna goes to actual prison now, and that's exactly right. If she hasn't been sentenced yet, so they will probably keep her there until the sentencing, and then as soon as that happens, She will be transferred to prison from jail where she is now to prison. That's exactly right. Hey, Tinfoil Hat Society has been a member for 13 months. Yay. Thank you so much. We really appreciate that. Andrew Brett, now when do they try Wendy? Well, they haven't even charged Wendy. So we are looking at a long way off if they ever do charge Wendy. I've got my Google alerts set, but thus far, no movement, no suggestion that they intend to charge Wendy. There are some issues with charging her that would make it more difficult. And yet, you could sure tell that the prosecution would like to do that. So I don't know if the case is over or not. Maddie wants to know, have you seen the video on Charlie's hurt toe? I saw that there was one, but I have not watched it yet. Angie Nicholson, surely Harvey had to know about all of this going on, especially with all that money going out to the trigger men and Katie. So did Harvey know about some of this? I think the prosecution would say that certainly Harvey knew about the bump. And I think the evidence was pretty clear around that, for example, he and Donna were babysitting Wendy's kids, and they wanted to make sure Wendy didn't find out that they were meeting with Charlie to talk about all this. And they were going downstairs and Harvey went down alone. Then you have Harvey meeting with Charlie at a sushi restaurant and they're talking. There's a recording that doesn't end up saying anything because they spot the person and say nothing. But for those reasons, I think the prosecution would feel pretty confident about his knowledge after the bump, but the knowledge beforehand is tougher for him. And he wasn't as vocal as Charlie and Donna once the bump happened. So I don't know exactly what they'll do with that. So far, again, no charges against Harvey. As far as the money going out, my guess is that Harvey had pretty little to do with that. Donna took care of the office. Donna took care of the check writing. I don't know that they would be able to prove that Harvey was intimately involved in that part of the business. He got the money from it. He earned the money for it, but actually writing the checks, I don't know. Now, there is the stop by Charlie's home when there were several pieces of evidence, such as the fact that it took an extra hour to get up to Tallahassee, is the fact that Donna's phone was near the house where Charlie lived, and Katie McBanoa said that Donna brought some cash to Charlie. All of those things were proof, the prosecution said, that Donna was paying the hitman, at least part of the money that they were receiving for the hit. She was paying that. But so Harvey was with her, right? Harvey was on that drive up to Tallahassee. So those pieces of evidence are the same, except for it wasn't Harvey's phone, but those things would still be the same, that he would have stopped by the house. So we'll just see. It's the big glaring difference is that he hasn't been charged. And so the state has not said that we think this is on Harvey. They haven't said that yet. So we'll just see if they do. Big fan of justice. Will Donna be in the same prison as Katie McBanoa? So great question, right? Because we've all been kind of wondering about that. And up until now, they made a pretty big point of separating the two of them. They have been in the same places, but never at the same time. I think that will continue to the extent they have an available prison and they can put them separately. I think that's what the state of Florida would want to do. Remember that Charlie's been sent on up to South Dakota to get him out of the Florida area for fear that there might be some threats to his life. So they could always do a solution like that for Donna if they felt like they needed to. White 007, since the journal is evidence, how long is the state required to keep it after conviction? Forever? That is a super interesting question. I don't actually know the answer to that, White 007. Here's what I'm thinking. There's no question that it has to be retained through the end of the appeal. And I'm guessing that, in fact, they continue to keep it just because it's a court record. If it's actually been admitted into evidence or used at a trial, I would think they would keep that. I know I would. Lawyers are pretty notorious for not wanting to throw things out. There are all these seminars about it where you have to, what do you have to keep? How long should you keep it? I myself have boxes and boxes of files that I still have because I just can't do it. All right, Andrew, and what immunity does it affect trying her? Um, Andrew, I'm not sure what you are asking me. Maybe ask it a little bit differently. I'm not sure exactly what you want me to answer. So I'm sorry. Sometimes I can't really tell. Mary, now that Donna has been found guilty, can she communicate to Charlie through email or calls? I don't know. I think it would certainly be something I think would be a good thing to allow families to continue to communicate. After all, it's not as if they can communicate to the outside world, but I don't think they'll be allowed to. That's just my guess. I mean, they're both convicted and they're convicted of conspiring with each other. So for that reason, I don't think they're going to be allowed to talk. Desiree, I'm going to hold off on answering that. Michelle, so the defense attorneys were dishonest about juror number 7's TikTok being deleted and about the amount of time she was offered to make her decision about testifying. Michelle, so I'm not going to go so far as dishonest. Just speaking personally, the believing that a TikTok was deleted, I think that her counsel are maybe even more technologically challenged than I am. So I kind of got the impression that they're like, yeah, this was deleted, and they don't know. They've never used TikTok before. They're like, yeah, it's been deleted, but they probably didn't know how to look for it. That's just a wild guess on my part. But that's how, if I were the court, that's how I would interpret it. They got a little embarrassed by the fact that the judge was able to point out, hey, look, this hasn't been deleted at all. And I think it will stop right there. As far as the decision about her testifying, I think they should have definitely put that in. Why even bother to hide it? Because the judge knows that. So I'm surprised they didn't mention it. I think it's just because they were talking around the issue that happened at trial and why they felt it was so unfair. And I think they weren't really thinking about the bigger question. But I thought it was a pretty important point. When he said that, I was like, wow, well, that is a significant point to me. The fact that you gave her overnight, you gave her a second chance and 30 minutes to think about it, I think that's really important. All right, Sarah, is there any sign that the law enforcement are preparing to arrest Wendy and Harvey? And do you know if the FBI, et cetera, have them under surveillance? I don't know. All I can say is, once again, I've got my Google alert set. I am ready to go if, in fact, it happens. So I don't know. You could tell from the interview with Georgia Kappelman after the trial, she uttered the words once again, stay tuned, which was what she had said before Donna's arrest. But remember that they really only arrested Donna when they did, just a week after Charlie's conviction, because she was leaving the country. So there's no deadline like that known with Harvey or with Wendy. So there's just not a deadline. Who knows? They could do it whenever. They could do it a year from now. So there's not a set time where they have to charge them or they have to walk away. And in some ways, there may be some purpose behind that as well. Even if they don't ever charge them, you would have to think about the fact that it constantly weighs on both Wendy and Harvey. It can't ever be out of their minds, I would think, that am I going to be charged? Is today the day I'm going to be arrested? Is this the last time I will fill in the blank? Anything that they're doing. And I think that is in and of itself a pretty significant punishment. But will it go into an actual arrest, charge, arrest, and trial? We got to wait on that one. Cutley has been a member for 18 months. That's awesome. Thank you, Cutley. Very, very much appreciated. Cutley, a long time, very appreciated supporter of the channel. And I'm looking for question marks again. Michelle, is there ever a consequence for an attorney to knowingly put false information in a motion? There sure is. There sure is. Let me give you an example, a recent example. There have been numerous attorneys around the country sanctioned for putting fake cases in their briefs. You might say, why would an attorney do that? Why would you put a fake case in? Well, what's happening is they're using AI, and AI is just hallucinating, and it knows they want a case that says this. So AI just creates a case that says exactly what the person wanted it to. And they put that in the brief, and the court says, and the problem is, without knowing that this is actually a fake case, think of what it could do. It could create a whole new body of law as judges say, "Oh, well, I had no idea, but the 11th Circuit has ruled this way, so I have to follow this law." So the courts are being very careful, and they are being very serious about sanctioning lawyers who use any kind of AI that creates a fake case, any kind of fake citation. They're being very hard on the attorneys for that, maybe throwing them off the case or fining them, because it is a really scary thing. It could actually make a difference in a case falsely, unfairly. So there's a good example. Shine on You Crazy Diamond asks, what is the difference between jail and prison? No tablet anymore. So I think she had the tablet because of the need to prepare for her trial. So she might not have the tablet now, even in jail. I don't know if she gets one just because. I think a lot of that depends on the actual jail or prison. And it's not as if everyone in jail gets a tablet and no one in prison does. I think it really depends on where you're incarcerated. And if it's one state, the rules might be one way. If it's another state, the rules could be entirely different. So as far as jail and prison, jail is intended to house people on a shorter term basis, so as they're going through the trial process. In truth, it's usually years long because trials are really not all that fast. So people will be in there a couple of years, even longer. One of the things Donna argued in one of her hearings was that she felt like it was unfair how long some people were being kept in the jail. They've been kept there for years and years and years. Then normally what happens if a person is convicted is they then get moved over to an actual prison. And either way, it's kind of a similar process. It's just a different location. One difference, a lot of jails have facilities which make it pretty easy to communicate and conference with the attorneys in the case, because that's the stage. It then can be more difficult in a prison setting because now it's at best appeal, or maybe even the appeals are all over. Carol Kierigol wants to know, will we be able to hear the phone calls when she is in prison instead of jail? I heard that it's not possible with every prison. That again really depends on the system itself as well as the state. It's not a uniform rule about that. We obviously got to hear the jail calls between Donna and Charlie. So, but we haven't heard anything more since then. Faisal asks, if Wendy is arrested, will she be out on bail? Almost certainly not, both because of the severity of the charge and also because no one else was allowed out during the wait for trial. So my guess is no. Gary, so Wendy gets charged only for conspiracy. Is there a statute of limitations on that charge alone? Good question, and a question of Florida law that I can't answer, Gary, but it's a really good one. So we'll write that down for future reference. Maybe I can take a look at that. Good question, Gary. Okay, Cecilia, can Donna request to be sent to the same prison facility after they lose final appeal? I assume you mean the same prison facility as Charlie, and probably not. I think he's in a men's facility and she would have to be in a women's facility. They rarely mix those, if ever. Or, I mean, I assume that's who you mean. I'm not sure who you meant. She would be in the same prison with. CJ wants to know, what will happen if Wendy and or Harvey is prosecuted, but some of the older witnesses' minds aren't as sharp, or witnesses have passed away? How can they use their prior testimonies, or can they? That is a great question, because it's a real problem, right? When you have a situation where time has passed, memories fade. It's just a normal thing. Evidence goes missing, memories fade, things happen. It can be more difficult to try the case. However, that works both directions. It's harder for the prosecution. It can also be harder for the defense. And so yes, it's a significant problem. And it's a problem that's being faced in many of the cases around the country where DNA is solving some very old cases. A lot of other information is gone by now, or witnesses are no longer around to testify. So I think CJ's question was using prior testimony. Typically, assuming the person is alive, they're going to have to testify as they presently remember, and only if there's a contradiction would anything be able to be used. In other words, they usually would not be allowed to just read that in. They can't just start reading from it and say, well, this is what this person said 2 years ago. Typically, if they're alive, they would be brought to trial. Now, if the person has passed away, and there may be arguments over whether or not testimony can be used if it was taken under the right circumstances. In this particular case, it's going to be especially hard since, for example, Wendy hasn't been tried yet. If she is even charged, well, she wasn't able to cross-examine the person. And so there will be arguments around the fundamental fairness of using testimony against her if she wasn't allowed to cross-examine the person. So anyway, it's complicated. How about that? I don't think there's a clear, straight up answer for you. All right, looking for question marks. Here we go. Andrew asking about Wendy being granted immunity and how much of an effect will that have on charging her? So her immunity was limited. It was limited to what she said at trial and to things derived from what she said at trial. She didn't get, completely off as far as anything. As far as what it will do to limit them, I personally don't think a lot, because it seemed fairly consistent with what she had already said to law enforcement when she was first interviewed. So to me, that's pretty much in the same ballpark as what she had said before, meaning it won't affect the ability to prosecute her. There may be contradictions that can be used for cross-examination, but your question was, would this affect the ability to prosecute her? And I don't think it will. I don't think it will substantially change their ability to prosecute her. So thanks, everybody. I will see you all on Monday at 7 p.m. for our next live stream. Thank you for joining me for this breaking news, and I will see you soon. It's taking me just a second. Sorry.